Thank you very much. Please be seated. This is the time set for oral argument in Vila versus Vila, our cause number CB150099. Let's begin with introductions of counsel for the appellant. Thank you, sir. Thank you.
Catherine Pearson on behalf of Lori Satorka. And Judah Davidson on behalf of David Villa.
Thank you very much. Let me go through a few preliminaries. Each side has 20 minutes. Therefore, since we have two appellees, I presume you've already discussed how you're going to divide that 20 minutes. We are recording the proceedings today, both audio and video, and the recordings will be available on our website and also on YouTube a little bit later, perhaps within a few days. Because of that, when you go to the podium, if you would please restate your name. That way, if anyone tunes in, they'll be able to identify who is speaking. Let me advise the parties and their counsel that we have read the briefs very carefully. We have reviewed pertinent portions of the record. The three of us have conferenced the case, and so we're familiar with the issues and the arguments that you have raised. So with that, then one last point, if the appellant would like to reserve time for rebuttal, when you go to the podium, if you will give us an indication of how much time you'd like, we'll try and make sure that we don't poach on your time and you'll actually end up with that time for rebuttal. And with that said, let's go ahead and begin.
Half of the appellants, I will try to reserve 5 minutes. Thank you for this extreme privilege of being in front of this panel. It is, for me, it's an extreme privilege. Brooks Gibson was requested by the family law court judge, Porter, to serve in a heated battle between two parents in a post-divorce matter. Could there be anything more challenging than addressing this type of an assignment? One in the mental health area has to use what tools they have to involve two emotional parents in regard to what's trying to be served as the best interest of a child. Based on his education and experience, he took on this assignment. The reason I think this is important to stress this aspect of the case is that, as this panel knows, there's no time for family law judges in the Superior Court. They rely on experts to feed them or give them information that will help them to deal with children's issues specifically that are usually involved with the mental health experts. Gibson had a mountain of concerns that were registered with him by both parents. That is obviously shown by the amount of time and the exhibits and tapes that he taped of the sessions. There was almost 1,000 emails that he went through. He rendered not one report, but 2 reports over a 1-year period of time. Gibson appeared then at a preliminary hearing. That's what's in front of you all, which happened on April 21st. Both counsel were there. Both counsel cross-examined him as to his competency. As you know from the record, the father had attacked his competency level. Every aspect of his competency was reviewed, and Judge Porter made the determination that he was both qualified and competent to partake in the work that he did. All of this is based on the Family Law Rule 74, which I know this court has addressed. In the brief I've given to you, though, was a kind of a relatively new case, 2014, which was the MCA case, and that's quoted there. What the MCA case talked about was where the trial court disgorged receivership fees, over $100,000. And what the court analyzed in that is the due process issues of what happens when a court reaches in and takes action against someone who's not been a party, not been served, maybe not even represented in the matter.
Isn't MCA, though, distinguishable? I mean, didn't that involve a corporate entity that was a receiver or an individual that was affiliated with a corporation? The individual then changes affiliations. And the request for disgorgement was not only against the individual, it was against the corporate entity as well, correct?
Right, yes, Your
And
Honor.
we don't have anything like that here.
Well, in essence, you have a disgorgement, and I'm going to touch on that right now in Rule 74, because that was the end result.
We do have a disgorgement, that's correct.
And not only disgorgement of partial fees, but the entire fee.
Absolutely right.
Okay.
But,
And
but with respect to the parties, with respect to due process, which I thought you were addressing, it seems to me that MCA is quite distinguishable from this case.
It may be, but I think it's arguable in that, again, the issues of persona jurisdiction, that they weren't a party to the litigation, that they were then under the, and then as
Well,
you,
the disgorgement order, though, in MCA, as I recall, and I interrupted you and I didn't mean to do that, but sought disgorgement against an entity or an individual, and again, I confuse which they are in my memory, that was not the receiver, correct?
that's correct, that's correct.
And isn't that quite different than we've got in this context? Your client was doing work pursuant to the court order, was equivalent of the receiver, to use the MCA analogy. And I don't think MCA stands for the proposition that you can't require disgorgement from a receiver. It says you can't require disgorgement from someone who was acting with the receiver but wasn't the receiver.
Well, and that's where I think the arguments are analogous. And then also remember in the brief, I quoted you the case in the answering brief where the disgorgement issues under the Register of Contractors or however that was were set out that it should be a statutory right, not an equitable right, so the court doesn't reach in. And that's what the court did in this case.
This was equitable disgorgement, no doubt. But what's your best proposition for the thought that in this context the court lacked jurisdiction to impose equitable disgorgement?
Great question, because it's Rule 74. When you look at Rule 74, which the Supreme Court drafted, they brought in experts to say we need your help for the trial court. In that rule, then, as you recall, there was only one issue for what would happen concerning fees with the court, with the trial court, and that has to do with the division.
Right.
So the court could make a division of that. No question about disgorgement or reduction.
Let me ask you this. Are you saying then that under 74, a trial court sitting in family court would have no jurisdiction, none whatsoever, to assess reasonableness of fees? Is that your position?
In regard to modifying the fee or handling the fee at that trial level, that's absolutely correct.
So whatever the family court coordinator charges, the court has no ability to alter or amend that, even though if it's wildly unreasonable.
That's correct, and here's why, Your Honor, and that's why it's a very important question for the tool that the courts have. Under Rule 74, and I believe it's B, the litigants can make a complaint. So you could make a complaint. So let's say I got Miss Dr. Smith to be my expert, and I find he's on the list that's been approved, and on the list he charges $500 an hour. I wake up to that fact. I file a complaint with the judge that, Your Honor, this isn't going to be reasonable for these types of fees, and we were going to move, and then that would give the court permission to make an adjustment.
Isn't that what happened here? I'm sorry.
No, go ahead.
Forgive me. But didn't Mr. Vila do that?
No, not until, what happened is that 1 year goes by with billing statements
Right.
and things like that. At the end of a year, then he challenges Mr. Gibson on the basis of his competency level. And in fact, in the record, if in page 66 of the record, line 15, came the question from Judge Porter, isn't the issue of fee reasonableness a different issue? That's a different issue. File an objection with the court. That was never done. So, but let me go back to answer your question on why that's so important. As we know, money dictates our culture, okay? If I'm the person with a client and I call Dr. Smith and I say, listen, you've just been appointed. Let me tell you, my client pays their bill on time and we've never filed one objection on any type of billing statement. Where do I have Dr. Smith? Or on the other side, because believe me, that psychologically has an impact on the person that you've engaged. In the other side of the coin is that type of person that causes all types of headaches on their fee. Oh, we've heard that this lady's had 3 different lawyers. In this case, these folks have had multiple different lawyers, each of them.
But if I hear your argument right, as it's textually hitched to Rule 74, all the things that you're describing the trial court would have no authority to do anything about?
No, no. In the essence, back in subsection B, they would have. If there's
But only on the intake, right? What you're saying is, if let's say family court coordinator is appointed 12 months later, billed $2 million for fees to the parties, I think you're saying, well, you're going to have to figure out how to pay that the trial court would have no ability to look at reasonableness.
But, well, the reasonableness, Your Honor, would quite frankly happen in the real world on the monthly statements that came out.
Let's compress that from 12 months down to $2 million for 2 months' services. If I hear you right, there's nothing the trial court could do.
I believe when they adopted Rule 74, you're right. Now, but that doesn't mean there's no remedy. So let me be clear on that. What I believe the Supreme Court did when they crafted Rule 74 was to have a rule so that the trial court could take care of situations of complaints, divide it up if one litigant is being unfair, one parent's being unfair, but not to get into the reasonableness of the fee. That doesn't mean that the person that's billed the fee doesn't have a forum for that. It's just not in the family law court.
What would the forum be?
It would be the civil court. Professional fees are always reviewable for their reasonableness and appropriateness in the civil court. Accountant's fees, lawyers' fees, even professional fees like this.
Aren't those typical, unless you use probate as an example, where
Yes.
fees constantly have to be approved? They're approved by the court where the work is done, as opposed to a stranger.
Well, but you see, in the family law court, it's just a whole different animal in that you're dealing with children, you're dealing with emotional issues.
Aren't fee requests, though, and fee shifting, aren't those subject to court approval even in family court?
Exactly, but if you were correct, and you could be, the forum would be to take that as a separate matter. In this case, Mr. Gibson would have been sued in the civil court, saying this fee isn't appropriate. You'd have the professionals to do it, and it would be a different forum than where the prejudice may hit the trier of fact in regard to issues affecting a family. That's why I think they crafted it in that way, not to get engaged in that type of situation with the professionals that they need. See, I'm saying that they need professionals in the family law court, and now you're stepping in that's going to do a chilling effect on any professional.
And I understand your position. I guess I just have never thought of a world or a type of professional service that would be provided at the request of the parties pursuant to court order, where the court and fees needed to be incurred by the parties, where the court wouldn't have some look back, some reasonableness screen, and I can't think of any other context where that would exist.
Well, I believe I gave you the case, and I'll have to look at it. What we're looking is on disgorgement in regard to the civil matter, and I quoted your case there. Rule 74, at this day and age, I'm sure the Supreme Court, because they talk about the division of fees, why didn't they incorporate at that point then? And I think there was sound reasoning why they didn't give jurisdiction to the trial judge, so the trial judge doesn't have to be a gatekeeper for those types of petitions to come in. Because you could imagine there's going to be a loser in every one of these cases generally. Somebody's going to be unhappy, and they're not going to be happy paying the fee, and so now the expert's got to go defend themselves. In this case, you'll see...
But they would have to defend themselves anyway. It would just, under your view, it would be a different forum where the family court judge, I suppose, presumably would be called as a witness to come testify.
They have immunity.
I'm struggling.
They have immunity, so they wouldn't be a witness in that type of...
what factual basis would there be for that civil proceeding?
Well, first off, a competent lawyer's got to decide, is this something that I'm going to bring an action on?
I understand.
So then that's where the gatekeeping starts. So I have to, usually if I'm going to attack a fee, I'm going to have an expert, another attorney, or a professional, in this case professional, tell me that fee was highly unreasonable, should have never been charged. All right, now the fact finder can decide that. And the person attacked can defend it properly, which Mr. Gibson was never given that opportunity in this case. Just to disgorge everything.
Didn't he have... It wasn't really, one way to look at the record is the disgorgement was based on his failure to provide supporting documentation for his fee entries. Okay? That's one way to look at it. Would you agree?
But the record was submitted.
Well, let me ask you, isn't that one way to look at this?
Yes, Your Honor.
And didn't he have kind of many chances to do that?
No,
Okay.
he never was.
Tell me why.
Well, because when he sat in court and he had all of his billable records, you'll catch it from the record, the clerk didn't want, the Judge Porter didn't want the record and told him, take it with you because it's voluminous. So you'll see that in the record. He had to go back at the very end, take the exhibits, things off of it and leave with it. He faxed it in September when he first got word that something's amiss. He wasn't aware of the...
Wasn't he told at a court hearing he needed to justify his fees?
Yes, he was, but unfortunately, and in the affidavit they submitted, you'll see that he called continuously without any success, and for whatever reason, the clerk's office on the first order, it didn't get endorsed to him.
And I understand it with respect to the resulting order, but that doesn't displace what the directives were at the hearing, does it?
I'm sorry, Your Honor.
The fact that he may not have gotten a resulting minute entry doesn't negate what the court directed him to do at the hearing.
Well, if he knew or he should have known, and like I said, he had it wasn't a matter of him not having the records, he had them. He had them to produce to Judge Porter at the April hearing. It's just then a matter, what should have possibly been done in hindsight is an OSC to come in and have the reasonable, and again.
When did he file those, when did he lodge those supporting documents with the court?
In September, there's a reference to the fax being faxed into the clerk, which he had been dealing with the clerk as an expert, not a lawyer, dealing with the clerk saying, I need to get these records into you.
And is there an IR, instrument of record, affiliated with that? Is what document number for appeal purposes?
Yeah, I'd have to take a look at the docket, Your Honor, but that's from my recollection of the record was what was done.
Thank you.
And I appreciate your questions very much. Thank you.
Thank you.
Good morning. Catherine Pearson, along with Judith Abramson, on behalf of the Appellees. I want to be clear, those billing records, those very vanilla, chronological, itemized billing records that every professional should keep were never filed with the court. They're not on the docket because he never filed them. He filed a response in this case. He knows how to file. He knows how to file documents with the court, but he never filed those billing records. So you can look through. They're not in there because he never filed them. There was a long time between that April 21st hearing, and there was a lot of notice that occurred about that hearing. And those minute entries are clear. We're here to talk about your licensure issues and disgorgement. The trial court judge could not have been clearer with Mr. Gibson about what was going to occur. Disgorgement was clear. It was clear on March 4th, and it was very clear at that hearing. He told him 5 times. And at the very end, after the testimony, he told Mr. Gibson, look for my minute entry in about a week. I'm going to issue an order. And if I issue that order, I'm going to require you to issue billing records for the court so that I can review them and that the parties can object, so that we can have the parties just pay reasonable fees in this case. We only get to unjust enrichment because he never paid those fees. So we can't turn unjust enrichment on its head and try to backdoor into some constitutional issue because he never did what he was supposed to do. It's absurd. He didn't raise it below, and we shouldn't get to it now. He was paid $11,465 for 2 couple-page reports over a 12-month period. It's egregious. And Judge Porter told him at that hearing, it's in the transcript, your fees are excessive. He was on notice of that at that hearing. There's a reason that's clear in the record why he doesn't submit those records. And it's not because this is complicated. He's sidestepping, he's dancing, he's delaying because he knows that there's no justification for these fees. And everything else, the reason we're on appeal is just backfilling because he doesn't want to reimburse. And so the AutoZone case that they invent, that they try to cram into this simple Rule 74 case, that case is about consumer fraud, where there is a clear remedy, and that remedy says you reimburse consumers. And by analogy, if your fees are excessive, you reimburse the parents who paid you those fees.
Counsel, let me ask you, because you're talking about equitable concepts, and I have some follow-up that I want to ask you when we get there. But how do we get to equity? Title 25, and this and other courts have been pretty clear that you need to look at a statutory authorization to do something in family court. That's the backdrop. And then Rule 74, which really doesn't cite reasonableness of fees, although if you look just the right way, you can see a flick of that. How do we get from Title 25 and Rule 74 to equitable remedies in this context?
So the court a family court has broad power to protect the interests of children. And the Supreme Court adopts Rule 74. And as Mr. Charles in passing mentions, that parenting coordinator enjoys immunity. So this broad notion that we can just file some separate action for his excessive fees, I'm not sure that we can. Because the appointing order is clear when there is a limited delegation of duties. And it's very clear because the court always has to protect the interests of the child. And the parenting coordinator can only go so far. And the trial court has to continue to oversee that appointed agent. And if they overstep their bounds, the court has jurisdiction over them. And Mr. Gibson, and I would ask the court to have judicial notice of this, Mr. Gibson has availed himself of the trial court's power to seek a court order to have parents pay him fees when they haven't paid him. And that would be in FC 2009-07-1101, FC 004-004345.
Counsel, let me ask you, I appreciate what you're saying, but the fact that it has been done somewhere else in another case may or may not be an answer to my question of what's the basis to cut to equity in Title 25 and then under Rule 74?
Because the court has inherent powers.
And I understand that, but again, family court, it strikes me that there have been cases that say, look, if it's not authorized either by or under a statute, you can't just sort of go doing it. That inherent authority in Title 25 is more limited than it might be, for example, in construing the common law in a civil case. And so that's the concept that I'm struggling a little bit with.
So if you read Rule 74 as a whole, it grants immunity for these parenting coordinators. It gives them the ability to collect fees and for the court to apportion fees as between the parents. And when you read the rule as a whole, and when you read this appointing order as well, the judge required Mr. Gibson to collect his fees in advance, which he didn't do in this case. So he collected a whole lot of fees after the fact. So there isn't this ability to go to the court ahead of time and say he's overcharging us and we don't want to pay that money. So that remedy doesn't always work in reality. And when it doesn't, this notion of bringing a separate proceeding is not expedient. It undercuts basic judicial principles. And
Let me interrupt you, Ms. Pearson, because I don't think you've made this argument, but I'm looking closely at the language of Rule 74, and specifically I'm looking at Rule 74D, which describes the persons who can serve as a parenting coordinator. And the last sentence to that rule says the court can set additional requirements for service as a parenting coordinator. Would that perhaps give the court the inherent authority to set an additional requirement that a parenting coordinator charge a reasonable fee?
it's under the procedure heading of Rule 74, but under that, and not under fees, that language.
It's under D, who can serve as a parenting coordinator, and the court can
Is
set
that the-
additional requirements for service as a parenting coordinator. I'm not sure why that wouldn't allow the court to require that a parenting coordinator charge reasonable fees.
I think certainly when you drawing on that language, Your Honor, and the language as a whole, read as a whole, and the way that courts generally treat appointed agents, courts can and must control them, and because otherwise what happens here occurs.
May I? Oh,
No, go ahead.
forgive me, maybe I'm looking at this too simplistically. If I understood what Mr. Charles said in his opening remarks, is that the court cannot just, as a freewheeling agency or entity, go in and determine the reasonableness of fees. But if there's an objection to the fees, then we'll come back to which court does this, but a court then can address those objections. And I raised with him whether there had been objections to the fees here. And I called back up on the record, and I looked at Mr. Viola's motion to discharge Brooks Gibson from appointment as the parenting coordinator. This is at the record at...
Is 118?
Yes, it's 118. Forgive me, I'm a little farsighted, nearsighted, when you get older, the eyes go. And at PDF page 3, he very clearly asserts that the billing practices have been inappropriate, he has overbilled, he's not billed at regular intervals, failed to provide billings, and so forth. It strikes me that those are objections to the fees that Mr. Gibson was charging and also to the methodology in which he was keeping time. Therefore, doesn't the court, according to Mr. Charles, have the right to then address the reasonableness of the fees? Am I missing something? I'm going to be asking you that, Mr. Charles, in your reply, but it's right here.
I agree, Your Honor. And the only reason why we're here is because he didn't file his billing statement, so we couldn't file objections. So
Particular objections, I guess.
more particular, like detailed objections on a line-by-line item to determine the appropriate fees that the party should have provided for the services. He didn't participate in good faith, assuming he shouldn't have been discharged for cause initially.
And that's not an issue before this court, correct?
It's not. I think Mr. Charles maybe opened the door on that with his reply brief, but
I understand there may be different points of view, but that's not.
But it's not an issue before because I think looking at the language of the objections, certainly the objection language within Rule 74 is not so narrow in scope as to only we don't like his procedures. I think if there are billing objections, those should be raised. And again, to just remind the court, he did not follow the appointing order here because he didn't draw down a retainer. He didn't charge the fees in advance as set forth.
But aren't we here really at least one way to look at it, is that he didn't provide support to show that the fees he charged were reasonable for the services performed. Isn't that one way to look at this case?
Yes, Your Honor.
So it's not, and I understand there may be procedural irregularities with respect to compliance with the appointing order, but I think that's kind of the core of why we're here, isn't it?
Yes. $11,465 for 2 reports. And to I mean, the transcript was clear. He required them to copy them on all the emails and didn't provide any input on them, and would just have a blanket, like, invoice for, like, $700 for reviewing emails. But no comment, no substantive response. It's a lot for parents to pay. And that's the sort of oversight that courts should have over appointed agents, over parenting coordinators. It's certainly contemplated by Rule 74. Thank you.
Mr. Charles? And if you could, sir, would you address my question about the objections at Record on Appeal 118?
And I'm sorry, Your Honor, in regard to?
Well, I raised, when Ms. Pearson was making her remarks, whether Mr. Vila had in fact objected to the fees charged by Mr. Gibson, and the Record 118, Mr. Vila's motion to discharge Brooks Gibson from appointment as parenting coordinator and for return of fees paid to him really does detail, although in descriptive terms, objections to the fees charged.
Sure. Your Honor, Judge Porter, if it's confusing, I believe Judge Porter on page 66, beginning at line 1, addresses that issue, which I believe wasn't clear to him. And in fact, it was just the opposite, if I may read. So if I haven't seen that, it's going to be 50-50 of whatever I determine his reasonable fees are, and then he'll get credit for his, and we'll get credit for hers. Abrams, well, I'm going to show is he doesn't do that, but he told her he has questioned his bill, said we were going to be overcharged, the court. But that is, then the court again, that's a different issue. The issue of the billing's a different issue. I suggest that's what his mindset was at that. Now listen to what his remedy was. The court, that's a different issue. That's a file an objection with the court. I have a problem with the parenting coordinator's fees issue. Okay. Meaning, if you have a problem with it, okay. File an objection.
Well, how were the Vilas in a position to file objections until they saw the billing statements, which your client never provided?
They did provide, Your Honor, over and over. Every month he provided billings. And in the record on page 59, line 6, Judge Porter returns to Mr. Gibson his billing records and exhibits, tapes, and all like that. That he had. You remember, you're dealing with somebody that doesn't have a lawyer. He's going down bare by himself. And so he goes down there with all the stuff he's accumulated over 1 year of dealing with conflicting parents with issues like mom signing the boy up for one soccer league and dad signing a different soccer league, and how do you resolve those issues with the parents? And they got the bill every month. They saw what it was. And in fact,
why didn't he then submit those same bills, file those same bills as the court asked him to do in April?
He didn't understand procedurally what that meant, in the sense that he had the bills, the judge gave them back, they were marked exhibits.
From what you're describing, it sounds like he had a big stack of stuff.
Well,
that
he had
handed
his records
to the court,
and things.
and the court said, no, I want support for your billing statements, not the stuff.
And he had been submitting billing statements, I understand, to the parties. And in fact, the record will show.
My point is, if he did that, why didn't he then take
I'm
that
not
added step and give them to the court like the court asked?
I'm not sure. I can tell you from the record, from the affidavits, he consulted the clerks over and over. What do I do? What do I need to bring down?
Been in family court long enough to know that the clerk wasn't the final arbiter of decisions. Fair? I mean, he had done this sort of thing before.
I would think that he would know to get records in, but what does the layperson know that a China doll affidavit should or shouldn't be? Should he hire a lawyer? He asked several times in the transcript, should I hire a lawyer? Do I need a lawyer
but
for this?
The judge can't give him legal advice.
No,
The
I understand
judge,
that.
I thought, though, the judge made it pretty clear about what he was expecting, and that just never happened.
Well, it never happened, but it could have happened by a different procedure. In other words, when the order came in and the judge said, my gosh, they're going to disgorge the whole fee, that doesn't seem fair. I've already found them to be competent to do. I'll have an OSC, a half an hour hearing. Let's find out what's going on. There were other procedures that were less onerous than to just disgorge the entire fee from him. And let me suggest that, and so again, I know you understand, the frustration is we're dealing with people, and you have 80% of the people in family law without lawyers. 80% today. Now you have experts, and this is going to have a chilling effect on any expert that you got to hire a lawyer to go up against lawyers, because if you don't do it right, you're going to get chastised. And I suggest to you, as Judge Downey asked, where's the authority for this? Rule 74D talks about fees. If they wanted reasonable fees to be the authority of the court, they could have put that sentence in there. This wasn't drafted by the Supreme Court in a vacuum. They had the help of mental health people, lawyers, family law lawyers, everyone to draft a very comprehensive, good rule. And I'm suggesting to you it's not the jurisdiction of the trial judge to determine fees. There is a procedure for complaints. There is a procedure to follow it. And, Your Honor, again, I submitted to you, you asked the question, the AutoZone case talks about the procedure for disgorgement of fees, when it's equitable and when it's not. That's a huge remedy to take fees from somebody. That's huge. I urge this court to have a sobering reflect on it. That rule is clear. It is simple. It is clear. It gave the trial judge, Judge Porter, no jurisdiction in this situation, although I'm not saying he wasn't without complaints and other remedies that could have been afforded to litigants in this case. Thank you, you folks. Thank you for your questions very much.
Thank you, Mr. Charles, Ms. Pearson, Ms. Aberson. The court will take this matter under advisement and issue a decision in due course. We're going to recess, and if the attorneys for the Stefanovic versus Anderson are here and they're ready to start, we're a little bit ahead of schedule, which is also nice, and we can go ahead and start. If not, we'll be glad to wait until the appointed 10:15. So with that, thank you very much. Thank you, counsel.